Good morning, Congressman Altmaier, Ranking Member Fallon, and members and staff of the committee. I have been asked to provide testimony this morning on the issue of the impact of predators in long-term care facilities on small business operators. As the Congressman noted, my firm, myself, and my partner, Pat Doherty, recently represented a woman by the name of Lillian Guernsey, who's now deceased, and her son, Thomas Italy, arising out of two documented sexual assaults perpetrated upon Mrs. Guernsey by 31-year-old Daniel Statham. An overview of the circumstances surrounding Mr. Statham's admission to the Country Living Personal Care Home demonstrate in graphic fashion the need for some legislation to assist small business operators in avoiding the myriad of problems associated with accepting sexual offenders at their facilities without appropriate screening or consideration as to whether these individuals should be accepted into a setting where some of our most vulnerable citizens are placed for care. Steps need to be taken to ensure that our elderly and infirm citizens don't suffer the type of violent attack experienced by Lillian Guernsey at the hands of Mr. Statham. Mr. Statham was 31 years old at the time he raped Lillian Guernsey. At the time that he arrived at the Country Living Personal Care Home, he had had 8 prior adult arrests, 3 convictions, and 2 adult commitments to correctional facilities. In 1992 alone, he had been charged with no less than 11 offenses, some of which were violent offenses, and many of which he was not prosecuted for because he was determined to be incompetent to stand trial. However, in 1994, Statham was arrested in Lackawanna County, Pennsylvania as a result of an assault on his girlfriend, and he was sentenced to serve 1 to 3 years in prison. Shortly thereafter, he pled guilty to a charge of aggravated indecent assault in northeastern Pennsylvania in Wayne County and was sentenced to serve 3 to 6 years in a state correctional facility. In that case, Statham had taken a 13-year-old girl into a wooded area and raped her. Statham refused to participate in a sexual offender treatment program during his period of incarceration, and as a result, he maxed out his sentence. And this is where the case really becomes troubling. At the completion of Mr. Statham's sentence, he did not provide the Commonwealth of Pennsylvania with an address where he could go. As a result of that, the Commonwealth directed the state police to take him to the Northumberland County Prison. At that time, the judicial system in Northumberland County brought Statham before the court, and he was sentenced to time served and 6 months, 6 months probation. When the court made an inquiry as to whether that probation was in the mitigated range for the offense, the probation officer indicated, quote, "I have no idea. We have no information on the defendant at all." Therefore, Statham was permitted to leave the prison and taken first to the Omni One personal care home and then Country Living without even a rudimentary pre-sentence investigation having been performed. The order of court, which we've incorporated into the materials which we submitted for the consideration of the panel, stated the following. The court directs the defendant to take a bus to a halfway house in Scranton and to maintain his residence in Northumberland County. It was established during Mrs. Guernsey's trial against Country Living that Northumberland County prison officials had notified the personal care homes, both personal care homes where Mr. Statham had resided prior to the rape, that he had been sentenced for a violent sexual offense and that he was being released directly from a correctional facility. Lillian Guernsey was raped on February 27, 2002. My partner and I tried that case exactly 4 years to the date, beginning on February 26 of 2006. The events of February 27, 2002 could have been prevented if some initiatives which Mr. Bledsoe has been proposing around the country had been implemented. The Sexual Offender Assessment Report, which I have referenced in the materials provided to the panel, indicate in graphic detail the indignities visited upon Lillian Guernsey by Daniel Statham on that tragic evening. Lillian's story needed to be told as to what occurred to her on that evening, and her victimization unfolded during the trial which occurred. After she was assaulted, Lillian returned to Memphis, Tennessee with her son Tom, and he cared for his mom at his own home as best he could, but she lived out her days in a nursing home outside of Memphis. Lillian Guernsey died within 2 months of the conclusion of the trial brought on her behalf against Country Living Personal Care Home. She was 90 years old at the time of her death. As a result of the attack on Lillian Guernsey, Daniel Statham was charged with rape, sexual assault, and indecent assault. He currently is serving an extended prison sentence at the State Correctional Institution at Camp Hill. As a final observation, I would suggest to the members of this panel, with the very honorable work that you were doing here today, that some initiatives need to be in place by the time Daniel Statham is released from prison. Thank you.
Mr. McDonough, in your lawsuit, the court found that there were no reasonable attempts to create safeguards to protect residents. Can you identify some of the basic steps that nursing homes can take moving forward to address this type of problem?
I think, and I'm sensitive, Congressman Altmaier, to Mr. Cobal's concerns relative to the management of risk, and I think that the nursing home industry and the personal care home industry should aggressively look toward government. I know regulation is typically considered to be a bad thing, but in this particular instance, it's a good thing. In our case, as I tried to highlight, unfortunately, the criminal justice system and the court was essentially complicit in the victimization of Mrs. Guernsey. It seems to me that the most appropriate step has to be very detailed reporting requirements with respect to past criminal history, so that nursing home operators, without unnecessary government interference, can certainly have the tools available to them to make an informed decision as to whether or not a particular individual is an appropriate candidate for their facility. So it would seem to me that particularly when someone is referred to a long-term care facility directly from the criminal justice system, as was the case with Daniel Statham, that the referring agency should have an affirmative obligation to specifically detail that individual's past criminal history. I think as a threshold, that is a very minimum requirement that could be instituted. In that case, now in our particular case, it was established that the owner of the facility did in fact or had been made aware of Mr. Statham's background. So that wasn't quite as much an issue in our case, and it was one of the things that the court found to be particularly egregious about the home's conduct. But there has to be knowledge on the part of the operators of these facilities as to the nature of the person's prior offenses.
So do you believe, Mr. McDonough, that the state registries and background checks are adequate safeguards, or you're recommending them as a minimum?
Well, they're certainly a minimum safeguard, and then there has to be some additional consequences for the failure to properly notify the personal care homes and the nursing homes about the person's background. Here we had a breakdown in two separate probation departments, one in Wyoming County where the personal care facility at issue was located, as well as Northumberland County. So certainly the registration procedures for Megan's Law offenders in the Commonwealth of Pennsylvania, which is currently in place, needs to be enforced. And I think that federal congressional oversight of this issue is certainly warranted in light of the tragic consequences that have been documented before the panel this morning.